This week on Eon Law. The Federal Circuit has held that communications related to buying or licensing patents can form the basis for personal jurisdiction in the patent infringement lawsuit. The case of Apple Incorporated versus Zipit Wireless Incorporated involves Apple's appeal from a judgment of a federal court in California dismissing its complaint about the declaratory judgment of non-infringement against Zipit for lack of personal jurisdiction. Starting around 2013, Zipit first contacted Apple, which is based in the Northern District of California. They discussed the possibility of Apple buying or licensing the patents at issue, the technical details of Apple's alleged infringement of the patents, and other matters relating to the patents. Apple asserted that it didn't practice any claims of the Zipit patents and that the patents were invalid. Eventually, in 2020, Zipit sued Apple for alleged patent infringement in Georgia. Shortly thereafter, Apple filed a complaint in the Northern District of California seeking a declaratory judgment of non-infringement of the patents in suit. Zipit moves to dismiss Apple's complaint due to a lack of personal jurisdiction under Federal Rule of Civil Procedure 12b-2. The district court then considered whether the exercise of jurisdiction of the California court would be unreasonable. The exercise of jurisdiction over Zipit would be unreasonable because of Zipit's lack of binding obligations tying it to California and because Zipit's contacts with California all related to the attempted resolution of the status of the patents in suit, example, for the purpose of warning against infringement. The Federal Circuit noted that while going to court in California would create some burden for Zipit, given the distance from South Carolina, we are not convinced that this would be so unreasonably burdensome as to be unconstitutional. Zipit's communications with Apple arguably went further than attempting to settle the dispute, extending over the course of several years and reaching beyond license negotiations to include the sale of its patents. Thus, the Federal Circuit reversed the district court's dismissal and remanded the case for further proceedings. Eon Law. Unleashing Genius.